As we kick this off, I want to do just a quick moment to make some introductions. I'm going to have my colleagues, Norman, Brigen, to do a quick intro of themselves as well. But we've tried to pull together industry experts through this particular webinar, and we believe that Norman, Stein, Brigen, Winters really fit that bill. So let me turn to Norman really quick to give a himself.
Yeah, hi, I'm Norman Stein. I'm a professor emeritus at Drexel University, and I'm legal director and senior policy advisor at the Pension Rights Center.
And then Brigen, if you don't mind giving a quick intro of yourself.
Sure, thanks, Mike. I'm Brigen Winters. I'm with Groom Law Group. I head our policy and legislative group, and also on our executive committee. I work on kind of all aspects of legislative, regulatory, and compliance issues around retirement plans, as well as health and welfare plans and executive compensation arrangements. I've been at Groom, back at Groom for I guess over 20 years now, after serving as the tax counsel at the Committee on Ways and Means back in the late 90s, early 2000s. Great to be with you today. Thank you.
Fantastic. So Brigen and Norman, welcome. And for just a quick introduction of myself, I'll be your MC throughout this next 60 minutes. I run the sales organization of the Berwyn Group. The Berwyn Group helps pension funds, insurance carriers, 401k plans locate missing participants, identify decedents, find beneficiaries, and such. Again, we work with multiple segments. So as we think about some of the challenges that face our clients, I'll insert some of those insights as well as questions that might apply. So as we think about this particular webinar, I think it's fair to start to talk about what are some of the challenges and where those challenges really originate. But if we jump to the next slide, as we think about the death master file, which used to be the gold standard with respects to identifying individuals. If you can identify an individual as deceased, you can therefore stop an overpayment. It's pretty simple math. In 2011, there were significant changes to the way that the death master file was able to produce those deaths. Today, through our analytics, we track that the death master file produces about 16% of all possible deaths. There's also a delay there, so typically the death master file will produce those deaths around 4 to 6 weeks after death. With challenges here, the exposure to overpayments becomes greater and greater. As you fill that gap that's provided by the death master file with additional data sources, the timing of those data sources, the completeness of those data sources, and also the consistency of those with respect of how they're producing death information becomes more and more a challenge. So as we think about that, I want to ask Brigen and Norman a couple of questions to start this conversation. But as we think about the handling of overpayments and how that's changed, Brigen, if you don't mind starting, can you speak a little bit to the regulations in general? What are the regulations with respect to overpayments and managing those?
Sure, happy to. I mean, I think first it's important to kind of divide the world up between, you know, what was the status of regulations before the Secure 2.0 retirement reform legislation in 2022, and kind of what changes that brought, and then kind of what was the state of play before then. I think it's important to start with kind of the state of play before then, because some of those rules still carry over and create some of the uncertainty that occurs now as we wait for more regulatory guidance on the Secure 2.0, the kind of new regime. It's been a long-standing kind of issue that retirement plans have struggled with on how or whether to correct inadvertent benefit overpayments. They've tried to balance fiduciary obligations to the plan and other participants with issues of fairness to the recipients and issues of equity, and as well as administrative practicalities and complexities. Prior to Secure 2.0, both the Department of Labor and IRS guidance generally required fiduciaries to make reasonable attempts to recover overpayments and make the plan whole, depending on certain circumstances. And that really stemmed from a couple of different legal requirements. One under the fiduciary rules of ERISA, which require plan fiduciaries to discharge their duties in accordance with the plan documents, as well as general fiduciary duties. And under those rules, DOL, Department of Labor, had advised that there was, under the duty of prudence, some requirements on attempting to seek, amounts erroneously paid from the plan. In addition, under the Internal Revenue Code, which requires plans to follow plan terms, there was concern that overpayments could theoretically disqualify the plan to the extent they were not in accordance with the plan. And there was guidance from the IRS, most notably under the Employee Plans Compliance Resolution Program, that suggested that sponsors do need to attempt recovery of all but very, very small overpayments to maintain the tax qualified status of plans. So that's kind of the general state of play.
I appreciate that insight, Brigen. And you mentioned Secure 2.0, and I know that's been an interesting topic over the years. Norman, I know something that you've been following and looking into. Anything to comment with respect to Secure 2.0, and again, how the regulations have changed over the years?
Sure. There was an important, I think, distinction between the IRS correction procedures and the Department of Labor's views on recoupment. Labor Department had sort of a broad view of what fiduciary responsibility required. So, for example, if the costs of collection were going to be extreme relative to the amount that was going to be collected, the plan, of course, didn't have to try and collect. And the Department of Labor also, from time to time, had suggested that the plan didn't have to, but could consider hardship to the participant in deciding whether to recoup. And also, I think both the IRS correction procedures and Department of Labor said you didn't have to recoup against participants, you had to get the money from somewhere. So if a third-party administrator made a calculation error, the plan would actually have a choice, although it was a choice that I think was subject to contractual restrictions in the contract between the service provider and the plan. The IRS took a position, though, that the plan risked disqualification if it did not attempt to recoup. And that meant employers really, or plan sponsors and plans, really didn't have too much of a choice in terms of complying with the rules that the IRS wanted you to follow, that you had to try to recoup. And this created two real problems, one from the plan sponsor side and one from the participant side. From the plan sponsor side, plan sponsors often didn't want to recoup, but felt that the guidance that the correction procedures prescribed by the IRS required them to. Right. So one set of concerns came from people who sponsor the plan, who said basically, I don't want to have to go after a participant who had nothing to do with the error, and it's going to create hardship to the participant down the road if I try and recoup benefits. From the participant's standpoint, the participant was an innocent party in most cases. They didn't know that they were getting more than they were supposed to get. In any event, the benefit was going to now be reduced to what the correct amount was, which was already a hardship. And now they had to go ahead and pay back the benefits either in a lump sum or have a benefit reduction. And the benefit reduction we saw at the Pension Rights Center could often exceed 50%. So you had these elderly people who were reliant on their retirement benefits had made plans based on getting a certain stream of income, and all of a sudden that income was significantly cut in a lot of cases. And to top it all off, the plan could also, in fact, under early IRS procedures, correction procedures, was required to assess interest as well. So there was a lot of discontent from the community as a whole for different reasons, I suppose, with the IRS approach. And the IRS did make some changes over time to suggest circumstances in which the plan did not have to recoup. But I guess this was in 2015, the Pension Rights Center convened a group that included both plan side people and participant representatives, and began speaking with Congress about trying to address these two significant problems. One, that the plan sponsor didn't have sufficient discretion, and the other was creating protections that would apply to participants. And I don't know, I've been talking for maybe 5 or 6 minutes now about the history. I don't know whether you want me to summarize the protections in Secure 2 or whether that should wait until later in today's webinar.
Well, I think it's a meaningful topic, but let's just pause for one moment on that, because I think as we think about this, I'm curious, and as we go to the next slide, we'd like to do a poll question as well. So part of this is like the understanding. What we've found is an audit. If you know you have a problem, you're going to solve for the problem. Most people don't realize that they have overpayments in their fund. So I'm curious to the audience, are you concerned about hidden overpayments in your fund? If you don't mind, take just a moment here, do yes or no. It's the beauty of a yes or no question, is hopefully it doesn't take a long time, then we'll show the results. Again, we'll be able to provide these later on as well, but curious from an audience perspective. All right. And as we think about kind of the transition from this, so there are the requirements of when, so a lot of people, it is on your mind. So this is, and I appreciate the honesty there too, because it is one of those challenges, right? As we think about the requirements then of those overpayments, I'm curious. So Brigen, from a regulatory perspective or from a legal perspective, what are the requirements of a pension plan when an overpayment is discovered?
Well, I noted the kind of as did Norman, the state of the play kind of prior to Secure 2.0, as a result of, I think, work that Norman and the Pension Rights Center and others did in providing feedback, and then work that the Hill did in drafting and Congress passing and the president signing the legislation that contains Secure 2.0. There are now additional rules and protections, both for plans and participants, with respect to what are the applicable rules when there is a inadvertent benefit overpayment. And basically, to generally summarize the rules, under the new Secure 2.0 framework, a plan fiduciary is treated as not violating ERISA if the fiduciary determines, in its discretion, not to seek recovery of an overpayment, subject to a couple of limited caveats, including, in the case of a defined benefit pension plan, the failure to collect the overpayments cannot materially affect the plan's ability to pay other benefits, and that's there you're taking into account the application of the minimum funding rules and where the plan stands, as well as if there was a fiduciary breach involved that resulted in the overpayment, then there may be an obligation of the plan to pursue that fiduciary. But if there's established procedures to prevent overpayments and the fiduciaries follow those procedures, then that overpayment will not give rise to a breach. And then on top of that, Secure 2.0 also provides that if given all that, if a plan fiduciary still chooses to reduce future benefit payments to correct an overpayment or seek recovery of that overpayment, fiduciary can still qualify for relief under the statute. But it provides a series of conditions and limitations where the plan fiduciary does decide to seek recoupment from the participant or beneficiary. And I think there's a series of 9 or so limitations. In the case of I think 7 of the 9, there's a determination of whether the participant or beneficiary that received the overpayment was considered culpable in receiving that overpayment, and if so, some of those conditions and limitations, the first 7, would not apply. So that's kind of the general lay of the land, and those were changes made to ERISA. There are also corresponding changes to the Internal Revenue Code to protect the plan from using its qualified status under these new rules. Norman may have more to add to that, but that's kind of the general overview of how Secure 2.0 kind of changed the lay of the land and considerations that plan take into account when dealing with these situations.
Yeah. So one of the things that I think is sort of important, at least thinking about overpayments and why the group that I was part of thought that there needed to be change, the position of the of IRS and Treasury, and also to some extent the Department of Labor, was premised on the idea that the plan actually had a loss when it overpaid benefits. And when we had our initial meeting, there were maybe 20 actuaries and lawyers sitting around a table. A lawyer or actuary said, the plan isn't the one that suffers a loss in most cases in a defined benefit plan. And the reason the plan doesn't suffer a loss is because plans are subject to the funding rules, right? And the plan is funding the miscalculated benefit. So the plan actually is in some sense better off financially because the mistake was made than it would have been if it had not miscalculated the benefit. And thus it's not really the plan that has suffered the loss. I suppose it's the plan sponsor that has suffered the loss. And as I said earlier, in a lot of cases, the plan sponsor didn't really want to go ahead and collect or try and recoup the overpayments. The specific provisions that were designed to assist participants, the most important of them were the plan, when it pays an overpayment, can, when it cashes it, of course, immediately change the benefit to the correct amount, right? So the participant is no longer going to be getting the overpayment in the future. But the benefit, the correct benefit cannot be reduced by more than 10%. And in addition, you can't charge participants interest on an overpayment any longer if they're, as Brigen said, a non-culpable party. And as he said, there are, I think, seven protections. But the other important protection is that the plan, it's kind of a modified statute of limitations protection. If the plan doesn't catch the error within 3 years, it cannot collect overpayment. It can reduce, and of course it's required to reduce the benefit to the correct amount, but it cannot go back and try and recoup the overpayment. So this creates a real premium for plans that want to create the overpayment to make sure they have procedures in place that will catch the overpayment quickly and not wait 15 or 20 years. And of course, if they wait 15 or 20 years and discover it, the amount that they're going to recoup is going to be, extraordinarily high and painful for the participant. The other thing that Secure 2 does, which was kind of a technical problem, is what happens when you get a lump sum and you roll it over into an IRA. If it's an overpayment, technically it's not permitted to be rolled over into an IRA. And the Secure 2 says we're going to treat a rollover to an IRA of an overpayment as a proper rollover. And if ultimately the participant has to return the money to the plan, we'll consider that also a rollover from the IRA to the plan. So that resolves some sort of tricky and silly tax issues.
So kind of in the same vein, so a question that came in from the group was if there's a death benefit, so a pension plan that upon death the beneficiary gets a lump sum, can you offset that, any overpayment, with the death benefit that's paid? Brigen, I'll start with you, and then Norma, if you want to add any.
I'm sorry, what's, maybe I'm not following the fact pattern here. There's a lump sum death benefit. Can that be used to offset what? So like some overpayment that was paid to the
Correct.
That went alive?
Correct.
Well, I mean, I think first we are there, Norman did a nice job of going through some of the limitations, conditions where overpayments recovery are sought, including on the annuity, kind of the 10% rule. That's baked into the statute. That's pretty clear on its face. What's less clear is what are the rules with respect to lump sum payments, and those are dependent on DOL, future DOL guidance, which we don't yet have. And I think that's something that plans are struggling with now. Norman, I believe I think there are limitations as well on the ability to seek overpayments from a beneficiary that occurred with respect to the participant. Do I recall that correctly?
Even before the Secure 2.0, there was a view that you probably couldn't collect overpayments made to a participant from the participant's spousal beneficiary, right? That they're two separate benefits. So if you were overpaying a participant and the participant died, you might have, assuming you catch the error quickly, you might have a claim against the estate, but you couldn't reduce the spouse's survivor benefit to recoup what was overpaid to the spouse, to the participant's spouse.
And that's baked into is one of the, I think, first 7 conditions in the new statutory framework under Secure 2.0. Now, of course, we'll probably get into this more later. I think the trick comes up in that protection, along with some others, don't apply, as I said, where the participant or beneficiary was culpable and bore responsibility for the overpayment. And that's a very kind of fact-specific determination. We don't have, guidance on this yet, and I think that's something that plans are struggling with, depending on particular fact patterns. And I know Norman's had some, real life experience in this area.
Yeah. That was really helpful. And so I want to just be conscious of the other content we've got, but I would be remiss if we've touched on the beneficiary piece and the culpability of those beneficiaries, the participant. One question that came from the audience was, and I'll read it verbatim, are proof of life affidavits, a good idea and worth the effort? And is suspending benefits due to lack of response appropriate?
Yeah, one of the problems with the statute, with Secure 2.0, that's going to have to be worked out over the next several years, unfortunately, probably through litigation rather than regulation, is what do we mean by non-culpable participant? Because if you're a non-culpable participant, you get these protections. If you're culpable in one way or another, you knew about the error and didn't tell the plan, or you contributed to the error by giving the plan false information, or cashing a check after a participant dies, for example. That's going to have to be worked out. And we recently saw a case at the Pension Rights Center where the participant who came to us had suffered significant brain injury requiring operations, and after the operation, she had significant cognitive impairment and was almost fully blind. And she was unaware of a plan provision that said, when you get Social Security benefits, you gotta, we're going to reduce your benefit. There's a supplement that's paid until you get Social Security disability benefits. And the plan said, you know, she didn't let us know. And she said, I didn't understand all this, even though there was some, you know, there's a paragraph in the plan, in the summary plan description. So question was whether culpability was going to be determined based on you know, the individual, and whether the individual itself is culpable from a subjective viewpoint, or whether there was going to be an objective standard. And fortunately, the plan had sympathy for her, and we didn't have to litigate. But I think that the issue of what we mean by culpable is likely to come up, and the statute doesn't really, it gives a definition, but it's probably not a complete definition.
That, you know, that's something that I think plans are struggling with quite a bit. I mean, it's very, as I said, very facts and circumstances. It's not a clear definition in practice. I mean, there are, I think, pretty typical fact patterns that may not have some of those elements, like the case Norman just talked about, where the spouse or beneficiary just keeps collecting, you know, for example, the life payments that were due to the participant, you know, and didn't notify the plan for some period of time. And that's where it gets, I think, trickier and tougher for a plan to say that there wasn't culpability there.
Yeah. Something else that is that Treasury was very concerned about, and this may seem like a non sequitur at this point because we haven't been talking about this. The protections for participants don't excuse the plan when you're talking about a Section 415 violation or 401A17 violation. That you still have to attempt to recoup against people who get larger benefits than the maximum that they're permitted under the code.
No, that's helpful, and I think that leads us into a good next question as well. So one of the challenges is understanding the beneficiaries that you have within your population. So if the principal dies, understanding who is responsible, who's gonna let you know that they died if the plan isn't notified through a death audit provider, for example. So we go to the next slide, our next polling question. Are you confident you have up-to-date beneficiary contact information should an overpayment occur? So how do you identify that particular person to reach out to? So instead of two answers, we've given you three. We'll give people just a couple of moments here to answer this. All right. All right, so interesting. So this is, and it's always the contact information. I'd be curious to unpack this somewhat. It's kind of like the other response, but what we'll see is there could be a beneficiary that is at time of when the participant registered that beneficiary, that is, for example, their current spouse. There's a lot of different things that we can talk about with respect to, is that still the spouse, even though that person has been divorced and remarried, but that person's on the documents. We'll save that for another time. But it's a good segue into the regulation and the future of regulations. So the next topic I want to transition into is really, where do you see? So Brigen, I'll start with you and then turn to Norman, but is there anything that you see coming in the future with respect to overpayment regulations? What do you foresee? What's your crystal ball say? And what are things that those that are in attendance can think about?
Well, I think, as I said, we are waiting. We are waiting for more guidance. It's not clear how quickly that guidance will come out. It's a very complicated area, and Secure 2.0 kind of built upon the first Secure just a few years before, and has led to just a whole ton of both required and needed kind of regulatory guidance initiatives, both from the Department of Labor and the IRS and Treasury. So I think there's quite a backlog. There was a lot put on their plate. Not clear how quickly all that will come out. A couple areas that, on which to be on the lookout for guidance include DOL rules under the new Secure 2.0 conditions and limitations. Unclear when we'll see that guidance, as well as there were several provisions, including this one under Secure 2.0, that affects the EPCRS self-correction provisions. As I indicated, there were rules in place under those pre 2.0 conditions are provisions that will need to be updated for Secure 2.0. In addition, there was a separate section of Secure 2.0 that significantly expanded those self-correction provisions for inadvertent errors. So I think all of that's going to need to be updated. I know that's on the IRS kind of business plan, but that's another area on which to look for future guidance.
Remember, what do you see from your perspective?
Well, I think there's one of the things that we generally don't talk about in the in this area is defined contribution plans, and I think that's probably an area where we're going to need some additional guidance about when a plan that makes a mistake in paying a benefit and defined contribution plan has to go ahead and recoup. There's also there are a couple of technical problems that were made, drafting errors in the statute. So, for example, there's a provision which has gotten a little bit of attention. One of the protections, the protection, 3-year protection that I mentioned earlier, is only available under the protection if there's no fraud or misrepresentation. And the problem that creates is the definition of culpability itself would not include somebody who engaged in fraud or misrepresentation. So why is this duplicative language over here wasn't intended to mean that you get the 3-year protection even if you were culpable, so long as your culpability didn't involve fraud or misrepresentation? I don't think that's what that was intended to mean. I think it was just a drafting error. And you probably don't get that protection if you're culpable even without fraud or misrepresentation, just because of the general way the statute is written. You're culpable if you knew of the error, for example, and didn't do anything about it. That's not necessarily fraud or misrepresentation. Or if you submitted incorrect information about your birthday or your spouse's birthday or something along those errors, that arguably fits culpability, but would fall short of fraud or misrepresentation in most cases. So that's something that, if there's a technical corrections bill, I think will be corrected. But if it's not corrected, it may create some problems.
And that's gonna depend on whether and when we see technical corrections is largely going to depend on when there can be a vehicle to pass those technical corrections. There was a staff draft release, but that's not going to happen on its own. It's going to be dependent probably on there being some kind of big omnibus appropriations type bill that would carry with it other other unrelated tax and other provisions.
No, that's really helpful. That's really helpful. I want to. There's some questions coming in. What I want to do is save some of those for a wrap up. So as we transition to the next, really kind of is a good segue from this conversation into our next topic, and really the wrap up is, if you could provide the audience with one recommendation around overpayments, what would that be? Brigen, let's start with you and then turn it to Norman.
Well, I really think, and it's hard to pinpoint one, but I think in a very general sense, it's kind of important to revisit, in light of kind of what we've gone through today, kind of the pre-Secure 2.0 ERISA and tax environment, and overlay the new Secure 2.0 rules. I think, plans have been and with the record keepers need to kind of revisit their overpayment procedures and make sure they're taking into account all that's transpired with these changes within the last 2 years. So I think that's what we're advising plans. It's hard to do hard and fast kind of plan amendments, but it is important to kind of look at your administrative procedures, take into account these new rules, try to come up with rules that are administrable and how to apply these. I think plans struggle with some of these what are, as Norman said, pretty subjective determinations. But just working with your outside record keepers, vendors, your internal plan procedures to implement these new rules, and not just keep operating like you did before. Also need to be on the lookout for additional guidance. I think it's likely to come in pieces, not all at once. So just kind of piecing together the new guidance as it comes out.
Yeah. It's hard to say it better than Brigen. I mean, I think you really want to look at your procedures. You certainly don't want to, you want procedures that are going to discover the error within 3 years. And you want to make sure that your outside providers, if they're doing calculations, are really understand what the plan says, and it's a tough area, I think, for plans. Two other things that I think, again, this may not follow your question, but maybe this goes back to the other question. I think there's also probably some need for help with what is interest. And to put this in the context of your current problem, your current question, I think plans should look at, or plan sponsors should look at what the plan says about how you calculate interest for overpayments, and also look at IRS guidance, which has some rules on this. Because I've seen cases where plans don't have a definition, and they say, well, we're going to take our investment performance over the last 10 years, and that'll be the interest rate. And that's. But anyway, I think this is something that should be on the checklist of plans that are reviewing their overpayments. Does the plan itself provide for interest? If it doesn't, you may not be able to collect interest, and if it does, you may want to look at what the interest rates are, make sure they're reasonable, and from the participant's perspective and the plan's perspective.
That's helpful, Brigen and Norman. Thank you for that. And just to add quickly is plan documentation. I know we didn't spend a tremendous amount of time speaking to this, but plan documentation, if it's defined within the plan, There's some security is the wrong word, but when you can define it and define it clearly, there's consistency in that approach. When it's not defined or poorly defined, that's where challenges can come in. That's what we see on a consistent basis. We see plans struggle with this regularly and trying to find and include a documented process for identifying decedents, identifying missing beneficiaries, and staying in touch with them. As we transition to the live Q&A, I do have a couple of questions and I want to transition into that. Some of the questions really become like the engagement, so how to and when to. So one question was around how to deal with return EFTs. So when this is kind of the transition we've seen, so 10, 15 years ago, physical checks were sent out. Those checks would come back and provide their own challenges. Plans did a lot of work to move to EFT, so direct deposit. But what happens when that EFT bounces back and you do not have confirmation of death? You cannot find that that person is indeed deceased and therefore assume they're living. Do you stop the payment and hope that they send a response? Do you continue to try to send the payment even though that's going to return? What do the regulations say there? Norman, anything from your point of view?
Well, I think this is something that the Department of Labor has had a lot of interest in. I mean, you have a fiduciary obligation to try and locate missing participants, and this would be a variation, I think, of on that. Whether you have to continue going through the really bizarre process of trying to deposit a check in an account that's no longer there. I'm not obviously speaking for anybody but myself, but it seems to me that that is a waste of planned resources, and you could check with the bank and make sure the account is closed. But beyond that, it does seem once you know the account's closed, using I guess it's not a lot of planned resources, but continuing to make the deposit seems something that shouldn't be required. But trying to find the participant, I think, is something that is required.
And that that's a complicated area into itself. It's one on which plans have struggled. I think plans would like more kind of set black and white requirements of what they need to do in the missing participant situation, and not just best practices of things they should do more, but more in the line of safe harbors, because it is a very big problem, and it's one on which the Department of Labor has done quite a bit of kind of audit and enforcement work. It's something that there was a provision in Secure 2.0 and has now been some sub-regulatory guidance out of the department. It's, I think, something sponsors haven't loved because it's more billed as a voluntary provision of information kind of outside of the normal 5500 reporting context, but it is a kind of an ongoing area on which I think plans and sponsors and regulators have struggled to strike the right balance.
Yeah, what Brigen's talking about is there's a provision in Secure 2.0 which instructs the Department of Labor to create a loss plan registry, which would have, I think, useful information for both for participants looking for benefits, but also in a lot of cases for plans and plan sponsors. But the information reported that needs to be reported to Department of Labor has concluded is not sufficient to have a really robust registry. So they asked employers if they would voluntarily submit some additional information, and I think the response from the plan sponsor community is that's asking a lot, because if there's a leak in the data from once we turn over to the Department of Labor, can we be sued? And So I'm not sure what's ultimately going to happen. It's a good idea, but it may not work to get this additional information.
I think
Yeah,
that's part of the
something
challenge.
else we haven't really talked about, and I just want to allude to it very briefly, which is there has been litigation when an error is made. The Secure 2.0 is clear. You reduce the benefit to the correct amount, but in some cases, participants have argued that they relied on the misinformation. It was a fiduciary breach, and you shouldn't be able to reduce the benefit, or at least the fiduciary should be responsible for continuing to pay the incorrectly calculated benefit. And there have been maybe 5 or 6 cases dealing with those facts, but I know there are lots and lots of other cases that have been settled. So that's something else to kind of think about. And when you're reviewing your procedures, you want to make sure understand to minimize participant misunderstanding about benefit calculations.
I think we see that consistently, and a question that did come up is, how do you determine when it's fraud and when it's just ignorance, right? They didn't know. So if somebody is receiving the benefit and it should have been reduced by, let's just say 50% because the principal died, the primary died, that person's still receiving 100%, and they're playing, they didn't know. How do you, A, is that fraud? And B, how would you suggest plans keep that in front of those members to ensure that they are very aware that if something happens, they need to let them know because it could reduce their benefit?
Yeah, well, I mean, that's, I talked a little bit about that earlier with that one case that I described with the disabled woman who, yeah, I mean, communication is really important, and there are different types. There are different types of errors that plans might make, and in some cases, the participant is just going to be unaware that there's anything they can do. But you want to, if you're a plan, you want to, I think, have constant communication, constant's putting it strongly, but you want to have effective communication with the participants so that they understand that if there's a certain event, it may affect the benefit, and the plan might periodically communicate with the participants, reminding them of any obligations, and not just do that electronically if it's really important, to make sure that to do it both electronically and in writing. There's also I think an issue with beneficiary designations. A lot of, I'm not even sure you call this overpayment, but mispayment takes place because, or at least contested payments take place because somebody has not updated their beneficiary form. They had a domestic partner, or not a legal one, but they had a somebody that they were very close to, and they designated them as beneficiary, and then they broke up and haven't had contact for 15 years, and adult children or minor children say we should be the beneficiaries. And so I think that kind of error, what a plan needs to do, or what it can do, all it can do really to try and avoid those sorts of problems, is try and remind people every couple of years to reconsider their beneficiary designation. And so that's, I'm not sure that's an overpayment problem so much as, but it's a parallel kind of problem.
Yeah, with that in mind too, and I'm curious to hear your feedback as well. As one of the questions or comments from the audience was this trend in seeing some of the plan sponsors move away from electric or EFT and back to paper checks. It gives that the ability to be able to communicate with that participant. And it also, they would have to physically deposit that check. So we think about fraud prevention, culpability. What are your thoughts there? Any general thoughts there?
Well, I'm not a plan administrator. To me, it sounds like something definitely worth thinking about. I don't know what the cost is, but it is an opportunity to have another communication moment with the participant, and that seems to me that kind of thinking I think is good thinking for people responsible for administering a plan.
Yeah, I don't think there's any one size fits all, but I do think some plans and administrators are looking at that. I mean, another area that might help address is just the area of, cyber fraud or fraud generally, where, having a physical check may make it a little easier to avoid, but not, it doesn't rule it out. I mean, we've seen cases, some of these cyber thieves are very sophisticated these days. So I think that's a whole other area, but a related area on which people I think are looking at physical checks, but still having to be diligent and really training their employees, training people to be on the lookout for phishing schemes and so on, because there have been very significant instances of people losing their benefits or losing in other cases settlements or what have you due to these basically criminals that are really taking advantage of the new kind of the new world in which we live.
Great. Well, I think one of the questions that came out as well is around really the advocacy, but also the requirement of a DB plan participants to name a beneficiary prior to commencement. And whether that's the date of hire or throughout their career, I think just that engagement overall, I think I've heard you both say this in the past also, is any communication you can have is good communication, but ensuring that the information you have is the most up to date. So if there's a beneficiary change or a beneficiary designation, that is identified early and often, as those might change as well. But any general comments with respect to that, in addition to what we've already talked through?
Yeah, I'm not. Yeah, reminding people to be current is always a great thing.
Right. Yeah, I don't have any much better answer than that. I think Norman did a nice job of summarizing that before. I do think it's important to remind people and people to be diligent on that. You don't want this, like the circumstance Norman talked about, you don't want that to occur where someone just forgets to update it and then the adult children are up in arms,
Yeah. Another thing too is I've seen this on occasion. Somebody gets married, doesn't tell their employer, and they die, and there's a beneficiary. And I think is in those situations you may want to double check and make sure the participant's not married before you honor the beneficiary designate, the non-spousal beneficiary designation. In part because the plan would have to, I think, may have been in a position where it has to make double payment. In that case, it'd be very hard to, if particularly the benefit's not large, to collect it against the non-spousal beneficiary. I mean, it may not be worth a lawsuit.
That's a really good point, and we see at the Berwyn Group, we do see, like, not only from an overpayment perspective, a death audit perspective, but also the missing beneficiary, bad address information. Switching away from EFT to physical check adds a layer, but it also adds a challenge, right? Is you have to have the right address, right? And so I want to be conscious of our time, but as we wrap up, I'd like to again extend my thanks and appreciation to Norman Stein and the Pension Rights Center, as well as Brigen Winters and Groom Law. And then on behalf of Berwyn University, those that have attended, again, you'll receive an email link within the next 24 hours with a recording of this video, as well as information on how to download the CLE or the CE requirement. But again, appreciate your time, and those panelists, I appreciate your involvement in this as well. Thank you, everybody.